Hi, I'm Ed Cross. I represent restoration professionals and environmental consultants nationwide. Welcome to the Restoration Lawyer newsletter. One problem in this industry is when an adjuster or a competitor arrives late at a project, criticizes the work being done or the prices being charged by second-guessing the judgment of the first responders who witnessed and inspected the actual damage firsthand. This leaves many restorers feeling vulnerable to the powerful insurance industry. The feature article in this edition of the newsletter is about a case where State Farm Insurance hired an unqualified investigator who performed an inspection 1 month after a residential sewage loss had been remediated and dried, without conducting its own moisture survey and based primarily on belated visual observations. State Farm concluded that the contractor, who had over 30 years of experience, didn't know what it was doing, and its positive moisture meter readings could only have been the result of a malfunctioning hammer probe. But State Farm didn't stop there. It then filed a lawsuit against the contractor, alleging that the materials it found wet were negligently demolished. The restoration contractor wanted to send a message that it would not tolerate this type of Monday morning quarterbacking. It took advantage of this opportunity to cast light on this unfair practice in a court of law. It refused to settle and went to trial. The court heard argument that State Farm's inspection was inadequate, its inspectors underqualified and ill-equipped, and that the conclusions were unreliable and erroneous. The court agreed, saying no to Monday morning quarterbacking and rendering a defense verdict in favor of the restoration contractor. Although trial court judgments are not law that's binding in other cases, the article in this issue can be a helpful negotiating tool to explain what's likely to happen to those who try to slash prices based on guesswork and inspections that are conducted after key evidence is gone. We must continually remind Monday morning quarterbacks of the fact that courts place high value on eyewitness testimony and disfavor conjecture and speculation. Also in this edition are my 7 survival tips for today's legal environment, the cover story of the March 2010 edition of Cleaning and Restoration magazine. If you haven't studied the new lead rules yet, now is the time to do it, and we've provided some helpful links to get you started. Finally, we've given some reports about the recent election and how these results may affect restoration contractors. I hope you find this newsletter informative. If you would like to subscribe, please send me an email at ehc@edcross.com. I welcome your comments. Thank you.